Welcome back, everyone. In this video, we're going to explore the court's role in settling disputes between states in what are called contentious cases. Disagreements between states are inevitable, and they arise regularly. They are a normal part of international relations. Neighboring states may, for example, disagree about the course of the land or maritime boundaries that separate them. States may also disagree about the use of force in international relations, the hunting of whales, or large-scale construction projects that could potentially harm the environment of neighboring states. The range of possible disagreements or disputes is endless. As you remember from Module 1, states are free to choose how they would like to settle their disputes in a peaceful manner. On occasion, states conclude that the best way to resolve a dispute is through the International Court of Justice. After negotiations have failed or reached a stalemate, states sometimes decide to entrust the resolution of their dispute to a third party, like the ICJ. But in order for the ICJ to be able to decide a dispute between two states, both disputing states have to consent to the court settling their dispute. In other words, both states must voluntarily submit their dispute to the court. States can't be forced into litigation at the ICJ against their will. If one state consents and the other does not, then the ICJ doesn't have jurisdiction. The term jurisdiction means that the court has the competence to decide the case before it. The need for consent, therefore, makes litigation at the ICJ fundamentally different from litigation in domestic courts. Why do you think this is the case? In a domestic setting, if two neighbors disagree on the boundary line that separates their property, one neighbor can bring a lawsuit against the other. The neighbor who files the lawsuit does not need to obtain the consent of the neighbor who receives the complaint. If the first neighbor has made a viable legal claim, then a domestic court will usually have the competence to hear the dispute without having to obtain the consent of both neighbors. But at the international level, the situation is quite different. Both parties to a dispute must be willing to submit the dispute to the ICJ. There are good reasons why this is the case. First, states are sovereign entities. States are the highest power or authority within their territory. They cannot be subject to any higher authority without their consent. States can't be forced to subject themselves to the will of any other state, international court, or international organization. States must voluntarily agree to do so, and this, in fact, happens regularly. Secondly, the need for consent can also be explained on a pragmatic level by the ICJ's inability to enforce its own judgments. The judgments of the ICJ are binding on the parties to a dispute. The litigants are obligated to comply with the ICJ's decision. But the court cannot rely on an international police force to enforce its judgments. This is again different from domestic legal systems. Domestic courts can and do rely on the police and other government officials to enforce judgments. Because the ICJ lacks an enforcement wing, it would be counterproductive to force states to litigate a dispute at the ICJ against their will. Compliance with the court's judgments depends on the willingness of states to resolve their disputes through litigation at the ICJ. I've explained why the consent of states is needed for the ICJ to have jurisdiction. But how do states go about expressing consent? States can signal their willingness to settle a dispute through the court in a number of different ways. First, states can reach a mutual agreement to bring a dispute to the court. This is called a special agreement, or a compromis in French. These agreements give the ICJ jurisdiction over them on a one-time basis with respect to an existing dispute. In other words, states conclude special agreements after a dispute has arisen. Special agreements have a notable advantage. They allow the parties to exercise some control over how the court settles the dispute. The parties can, for example, direct the court to settle only a part of the dispute, and they can also tell the court to apply a particular body of international law. In 1967, for example, Germany drew up special agreements with the Netherlands and Denmark regarding a disagreement about maritime delimitation in the North Sea. Germany disagreed with its neighbors about how they ought to draw their maritime boundary in the North Sea in the continental shelf area. These three states referred their dispute to the ICJ by special agreements. They specifically asked the court to decide on the legal rules governing this delimitation. The parties themselves then negotiated their maritime boundaries on the basis of the court's judgment. This is a good example of states using special agreements to limit the scope of the dispute to be settled by the court. States can also consent to the court's jurisdiction over disputes that may arise in the future. There are two ways that states can do this. First, states can conclude treaties that contain provisions that give the ICJ jurisdiction if a dispute arises about the treaty's application or interpretation. These treaty provisions are called compromissory clauses. In 2006, for example, Argentina brought a case against Uruguay by relying on a compromissory clause in a 1975 treaty concluded between them. Argentina claimed that Uruguay had violated the 1975 treaty by constructing pulp mills along the river Uruguay, which runs between the two countries. States can also consent by filing a declaration with the court to provide for its jurisdiction over future disputes. These are called optional clause declarations. Some declarations cover all potential disputes, but many declarations are careful to exclude certain types of disputes that states do not want to submit to the court. In order for the court to have jurisdiction, both parties to the dispute need to have filed such declarations. In 2010, for example, Australia brought a case against Japan on the basis of the optional clause declarations submitted by both states. In this case, Australia claimed that Japan's program for hunting whales for scientific research violated the International Convention for the Regulation of Whaling. The drafters of the ICJ statute anticipated that such declarations would form the main way that states would consent to the court's jurisdiction. But this has not been the case. Only about 70 states have filed optional clause declarations with the court. This shows that most states have been reluctant or unwilling to give the court broad jurisdiction over their disputes, without being able to consent on a case-by-case basis. As a result, special agreements and compromissory clauses remain very important ways to bring disputes before the court. In video 4, we'll explore what happens after parties have consented to the court's jurisdiction. We'll do this by looking at a number of cases that concern the protection of the environment. But in the next video, we'll look at the court's other role, as an advice giver within the UN system. I hope to see you there.